I wanted to put out an informational video related to the class action settlement that was announced last month, because so many people in so many different situations have reached out to me with questions. So I went directly to one of the sources. I reached out to a co-lead counsel, Steve Schwarz of the law firm Faraci Lange of Rochester, New York. He agreed to be part of this Q&A as a starting point to get information out. As you will find out, they've had a lot of work already to get this information out and get it ready for you. So I'm glad to have him here. Steve, welcome.
Thank you, Mayor. I appreciate being invited.
So before we begin, I want to explain a few things briefly, and I'm going to use the space here to put some titles in and give you guys an idea of where various discussion points happen in the video. So if you want to jump around or reference things later, use the titles over there. First off, the revelation of PFOA in the water here set off many different actions simultaneously. For the village as a municipality, our path began with bottled water, a consent order, a temporary, and then a permanent GAC filtration system on the municipal water supply. It led to many discussions with Saint-Gobain Performance Plastics and Honeywell, which led to interim settlement agreements that were between the village and the companies, where we got back a lot of the costs that we had up front and maintained our legal rights. We have a new water source on the horizon, which will be announced probably in the next month or two by New York State DEC. And then we'll have our own discussions with the companies. Now that path I just laid out is completely separate from this agreement, which we are talking about today. We as a village actually were not directly involved in this settlement agreement at all. My goal simply as mayor is to make sure that we are using our local government to get information out so that people have a starting point to understand all of this, and it is fairly complex. So I'm very glad to have Steve here. And the first thing that we're going to talk about is the timeline. So Steve, everyone has been asking, is there something they should have done now? Do they still have time to act? So can you walk us through what the timeline is over the next several months?
Sure. And again, thank you, Mayor, for inviting me to get this word out. And this will be the first of many opportunities for people to gain more information. So I appreciate this being a starting point, but it's not the ending point. There's going to be a lot of other information that's out. So first of all, the settlement was proposed to the court at the end of July, and on July 27th, the court granted preliminary approval of the settlement and also preliminary approval, excuse me, of the notice process. The notice process designed to reach out to people that could be eligible for any of the classes. So the notice per se will consist of an explanation of what the settlement's about. It will also contain a claim form and some other documents that if people want to participate in the settlement and they're eligible, they'll have to complete and submit. So that's going to happen, begin on August 26th, and mailings will go out to everyone who's on the village water system, as well as all of the people that we've identified who have been tested, have private wells in the town of Hoosick who have tested positive for PFOA. And again, that's going to go out to probably more people than are eligible, but it's the design of the notice program is to reach as many people as possible and then figure out who's eligible and who's not, as opposed to leaving people out. In addition to the mailed in notice, there's going to be a website that will be live by next week. And it's also going to contain all of the necessary documents. And what I would encourage people to do is, if you have family members or friends who have moved out of the area who may be eligible for one of the classes, you can direct them to the website. We're also going to do social media outreach that's going to provide information and sources and links to places where you can get information. And there's also going to be television advertising and advertising in local newspapers that are going to provide further ways for you to get the information you need to participate. And all that's going to start on August 26th. We're going to have schedule 2 public meetings to help people understand the process and what they need to do. They're going to occur on September 8th and 9th, and we're going to do them at the town rink to be as safe as we can with regard to COVID, and have an outdoor space, but yet have a roof. So in case it rains, we'll be covered. and we'll be getting more details out on that, but we expect that to be approximately 7 p.m. that we're going to do those two meetings. That's a Wednesday and a Thursday evening. So the process basically is that everyone who fits the definition of the classes that have been preliminary approved by the court would be eligible. So you don't have had to do anything up to this point. You know, you could not have had any contact with a lawyer, with me, or with any of my colleagues, and still you're in the ball game. You're not excluded. This is what's called an opt-out class, which means that in order to not be covered by the settlement, you have to opt out of it. And the deadline for doing that is going to be December 9th, 2021. You also have the right to object to the settlement for some reason, whether you think that it's not enough money, whether you think the way the money is being distributed is not correct. You have a right to object. You have to also do that by December 9th, 2021. All of that information will be in the notice packet that is mailed out and will be on the website. So this is all, in other words, everybody's going to have plenty of time to make decisions on what they want to do and whether they want to be included, and if they want to be included, to fill out the necessary paperwork. The deadline for submitting that necessary paperwork is not going to be until January 23rd, 2022. So there's no immediate rush for anybody to do anything, and no one is going to be excluded, but that will be a date that is important, because if you're going to be included in the settlement, you'll have to have done the necessary paperwork by January 23rd, 2022. So that's the basic deadline. And then the court has set February 2nd, 2022 as the final hearing date. And at that time, we will appear in court. And if people have objections to the settlement, they will be able to notify the court that they want to appear in court to object, and they can be heard under those circumstances. And there'll be details as to what you need to do in order to do that. And then after that, the court will rule on final settlement. The only caveat to that whole timeline is there is a requirement that a significant percentage of the people that are eligible participate in the settlement and don't opt out. We don't have any reason to believe that that significant percentage is not going to be met here. And one of the reasons that we have that confidence is that if you opt out, in order to do better than the settlement, you would have to get your own lawyer and prove all of the things that we've been able to prove so far and develop the evidence that we've been able to develop against these defendants. That has cost us, not including attorney costs, but we're talking about out-of-pocket costs, over $1 million so far to do. So the likelihood that anyone is going to be able to find a lawyer that's willing to shell out $1 million for the ability to get the types of damages that we're talking about is going to be zero, because nobody is going to recover $1 million for the damages that we're seeking in this case on an individual level. We don't have anybody that has a $20 million home that has lost $1 million in value in Hoosick Falls. So we don't think the significant percentage aspect of this is going to be a problem, but it is basically something that's built into the agreement. So assuming that we get the participation we get, and that percentage, by the way, is really the opt-out percentage. So in other words, it doesn't mean that we have to have a certain percentage of people that are eligible fill out claim forms. What it means is that a significant percentage can't opt out and decide to take their own lawsuits on. And that's why we feel pretty confident that's not going to happen. We expect that there are going to be some people that are not going to participate and not opt out, and those people will be bound by the settlement. In other words, the court will rule that their rights are precluded to go forward after that if they haven't opted out. But if they haven't submitted a claim form, they can't also participate in the settlement. They won't get any of the benefit of it. So it's important that if people want to get the benefit, that they fill out the claim forms and determine their eligibility, provide the documents that we're requesting that they provide. And that's the touchstone to getting to sharing in the settlement, which we think is a very good settlement that's going to be very beneficial to the people of Hoosick Falls and the town of Hoosick.
All right. That's great. Thank you. And just to, and we'll probably dive in a little more later to why people may want to opt out or how we relate to other possible claims or rights they have. But just to recap on the timeline, no one has missed anything yet. Your public outreach campaign is really going full speed next week. Websites going up, social media outreach, advertisements. The public meeting is scheduled for Wednesday, September 8th and Thursday, September 9th at the town of Hoosick Rink, likely 7 p.m. starts. The first deadline that people are looking at is the December 9th deadline to either opt out or object. And the really important deadline is January 23rd. That's where you have to make sure that you file to make sure you're part of the claim. Is that all right?
That's all correct.
Okay. So before we dive into the nuts and bolts of the settlement, I've had a lot of questions about how settlements work and the class distinction, how it is that people who didn't pursue any legal claims can actually be part of this settlement, even though they didn't actually, hire a lawyer and pursue this. So can you just briefly explain that so we can kind of understand how that works?
Sure. The class action device is designed for situations like this, where proving a case is really expensive and time consuming, and people's individual damages are insufficient to justify that type of expense for any lawyer or law firm to undertake. But in order to do this kind of action, you have to have uniform claims. In other words, you can't have a bunch of different people with a bunch of different types of damages all put into a class action. There has to be common questions of law and fact that the court will permit it to go forward as a class action. But if you have those common issues, and here we have the common issues of the conduct of the 4 companies that we've sued, we have the issue of what caused the contamination and how that happened. That's common to everybody. And with regard to the damages issues, we have common issues with regard to each of the classes. For instance, the class for property damage, we have the common issue of whether the PFOA contamination has devalued people's properties. For the nuisance claims, we have the common issue of everybody that was on a private well that was contaminated and that has a POET system in there, so that they have all suffered that similar fate and had that similar experience that would justify giving them all a similar recovery. And for medical monitoring, we have to prove that everybody that is exposed at a certain level has some increased risk of illness, and therefore that the medical monitoring would be beneficial for them. So we have to establish for a class action that that people in each of those classes have common issues of question fact and can be treated equally. And if we do that, then we can have certain people be representative plaintiffs in the case, actual human beings with names that bring the case, but they can bring it on behalf of everybody that's similarly situated, that under the same circumstances has the same type of claims. And when you do that, then what you have to do is get the court to say, number one, that it fits the class action rules, and that you have proven that there are common questions of fact that predominate, and that you can do it in an equitable fashion, deliver relief to people. And if the court approves that, then we go through this notice process where we have to give notice to people to have the option to get out of it if they decide they want to go it on their own. But if they don't do that, then the court can issue an order that basically binds everybody, whether they chose to be bound or not. And that is the end process here in February. Anybody that hasn't opted out, if the court approves the settlement, then everybody will be bound by its terms, whether they put in claims or not. So if you don't opt out, it is highly advantageous to file a claim form, because you're gonna lose rights and you won't get any benefit out of it. And we also don't think, again, that there's any benefit in opting out either, but that's the nature of a class action. So it's basically brought by some people on behalf of others that are similarly situated. And if the court agrees that it makes the most sense to do it in that fashion, both from the standpoint of the people, but also from the standpoint of the court, because the court has an interest in not having 5,000 individual cases that all have the same facts. They would rather have one case that deals with everything at once, much more expeditious for the court and better for judicial resources. So that's what a class action is. And in our case, what we were in the process of doing when the settlement was reached is the court was just about to make a decision as to whether it was going to certify the classes for trial against all 4 defendants. Now that has been put on hold for these 3 defendants, and the court is being asked to certify settlement classes against those 3 defendants. The 4th defendant, DuPont, has chosen not to participate in this, and we are proceeding with the litigation against DuPont. You're on mute now, Rob.
Yeah, I do that. I'm sorry. So that's something I wanted to ask about. And before we talk through the classes within the settlement, we know that the 3 companies are part of the settlement. And as you said, DuPont, the 4th, is not. So what does that mean for the settlement, and what does that mean for future actions?
So we've asked the court, and there's been a number of filings since the settlement was preliminary approved by the court, to go ahead and issue its decision against DuPont. The court hasn't issued that decision yet, but hasn't decided not to issue it either. So we're waiting. We expect that the court is going to do something in the next few weeks, we would expect, although we can't guarantee that. But that motion has been fully briefed since February, and the court has denied up to this point any further argument on it or any further briefing. So we do anticipate there's going to be a decision on that in the not too distant future. And the settlement is going to proceed on a sort of parallel track, where the court now has set the schedule that we've talked about for approval of the settlement against the 3 defendants. So we anticipate that we are optimistic that the court is going to certify the litigation against DuPont, and then we'll proceed to trial against DuPont, unless a second settlement is reached with them at some later point. But the settlement against the other 3 defendants will be hopefully completed by February of 2022. And we will begin distributing the proceeds of the settlement to the residents that qualify within 30 to 60 days after that.
Okay. So in a sense, for people who take part in the settlement, you're looking at probably the first half of 2022 is when you think things will be distributed. And
I think it'll be the first quarter. Yeah.
Okay. And with DuPont being the 4th who is not involved yet, there could be more coming.
Right. And we believe we have a strong case against DuPont. The law in New York will give DuPont the benefit of the settlement, in a sense that people can't collect twice for the same damages. So there would be an offset, but we think we will collect. We think we have a strong case against DuPont that we can prove that they are also partially responsible for the damages that have been caused. And we think that there will be further recovery at that point. We would expect that further recovery, if it all happens, to track the settlement pretty closely with regard to how it's distributed. So it would sort of be a second payment that we would expect to be made along the same terms, using the same methodology that we're proposing for the settlement.
Okay. All right. So now let's talk about the 4 classes. And I don't know if there's a specific distinction, but I know I have a path for the 4. When we talk about each class, I want to focus on who qualifies for it, how they qualify for it in terms of if there's some sort of ownership or some sort of timing that aligns to help people figure out that. And then what, if any, proof they have to provide to be involved. And then what the class means in terms of what would come out of it. And also what would they not be able to, I guess, file a claim on in the future if they agree to the class action. So those are kind of the questions. And I know that, we have residents of all types here. We have businesses, and I know that's something that we're going to talk about as well. I just want to make sure there's clarity on for everyone to find out which classes they would fall under, because I don't think you can fall under all 4. It's impossible, I think, but we'll find out. So the first class is the property damage class number 1, and this is focused on the municipal water users and the property owners. So if I have this right, these are residential property owners only. It's any property that was on the village water or municipal water line or water district, either way you want to refer to it, So even if you were outside the village but connected to the village water, that would count. Does that sound accurate so far?
Yes,
And these and the date specific to this was ownership on, I think it was December 16th of 2015. Is that correct?
that's correct.
So businesses would not fall under this.
Right. Remember that I said that in order to use this device as a class action, everybody's claims have to be common, both with regard to the liability issues and causation issues, but also with regard to the damages issues. So when it came to trying to evaluate the stigma that was caused by the contamination for a business, there was too much variation in that for us to do with commercial properties. We were able to do it for residential properties because we had a real estate expert economist who was able to study sales in the town of Hoosick and compare them to sales of residential properties in other jurisdictions that are close to Hoosick Falls but did not have PFOA contamination but had similar housing stock, and then compare the prices both before the contamination was found to after the contamination was found. And that study revealed that the prices in Hoosick Falls were diminished significantly in the first year of the contamination and continued to be diminished for 3 years after that, which is when he completed the study with data from 2019. So depending on the span of time, whether you looked at a 3-year period or an 8-year period with 5 years before and 3 years after, or just the 3 years after, the range was from about 8.75% to 21% of diminution between the comparable towns, using, again, trying to remove any confounding factors and comparing apples to apples with regard to the type of housing stock and that sort of thing. And the problem with commercial properties is they're too different to do that. You know, every commercial property has its own unique reasons for that people might buy it and might use it. And it was impossible for us to get enough symmetry there to do an analysis that would include the commercial property. So we were unable to include them in the class, and they were never part of the lawsuit in the first place. We always went for residential properties. One of the things that can kill you in a class action is if you put in too much variety, because that allows the defendants to say, there's too much variety, you can't do it as a class action, and the court will agree. So we have to narrow it down to the most common denominators, and residential properties were that common denominator.
Okay, so because this is a property damage specific class, if you were a renter at this time, you wouldn't qualify. It's just for owners, and it's just for residential owners. Yeah,
it's only these classes for the property damage are only for people who had ownership interest in the property, and they lost value of their property. They lost some of the equity that they had in their home.
And the specific date is December 16th, 2015. I'm guessing because that ties into, is it the Times Union article that sort of made everything really focused, or what was the rationale for that date choice?
That was the date that the EPA put out its recommendation for people to stop drinking the water and to not drink it. We know that there were dates before that PFOA was discovered, that it became known. There was a lot of information and misinformation that went on before that, but a date had to be set. You know, there's not a perfect date, but we needed a date. And the reason you need a date is basically this: that once the contamination was confirmed and that it was harmful, that is when the publicity came out that then started to change people's attitudes about whether they wanted to buy a house that had contaminated water. So okay. If you owned the property at that point, you owned it before that point, before all that happened. You owned it when it had its value that it had in 2015, and then you lost value after that. So that's the important point. If somebody bought a house that in 2017 or 2018, then our theory doesn't hold, because by that point people knew about the contamination, so they can't claim that the value that they paid wasn't factored in, that the PFOA wasn't factored in at that point. So that's why there's a point in time, and that was the point that was chosen in our settlement and adopted by the court.
Okay. And now I'm going to ask a little bit more about how it's going to be distributed in the percentage. But before we do that, because it's going to apply to the second class, the property damage class number 2 is for the private well owners who are outside the village in the town. So my understanding this is a town only residence, because village residents would have been on the water supply and they would belong to class 1. And they are for the owners of the property. And I think you said the property had to be tested and had to have received a POET filtration system. Is that correct?
No, actually,
Okay.
For this particular class, for the property damage private well class, it only has to have contamination in the well. They didn't have to have a POET system. For the nuisance class, you needed a POET system, but for the property damage class, you don't. And the justification for that is basically the law. In order to collect for diminution of value, there has to be contamination found on your property. There likely is some stigma effect for uncontaminated properties too in the town, but the law doesn't allow those people to recover. That the law in New York is very specific on stigma, and it requires contamination. So if you have contamination, a PFOA contamination in your well in the town of Hoosick, and you owned the property at the time that contamination was determined, and that's the second date. For this particular class, the important date is that you owned it when it was discovered that your property was contaminated. Then you are also entitled to diminution of your value of your home based upon the analysis done by our expert.
Okay, so I'm glad you clarified that. My apologies for initially starting that wrong. So this is in the town, this is owners, you had to have had your water tested and it had to have found, is there a specific amount of PFOA or it just had to be found?
Just has to have PFOA in the water.
Within the town of Hoosick?
Within the town of Hoosick, yes.
Okay. And the timing for this is you had to be the owner when it was initially discovered?
For the same reasons that we discussed before, because if you bought it after that and you knew about the contamination, then theoretically the loss of value had already occurred and you bought it at a reduced price because of that.
Okay. So for these homeowners, if they don't have the documentation or paperwork on the tests, how do they make sure that they're involved in this?
So we need, there's a documents that they can fill out to indicate that they own the property. They have to identify what the property is. We have data that came from the Department of Environmental Conservation and from the 2 defendants who are in the settlement that are actually responsible for the POET systems and for doing the testing. And so we have that data that the general administrator that's appointed and approved by the court will then be able to use to establish contamination at that home. But the people have to establish the date that they own the home. So that can be done in a variety of ways, with tax bills, with other types of documents that showed that they own the home, their deed. And we're going, the general administrator is going to, again, be as inclusive as possible and use whatever proof is publicly available. If people don't have any proof, we'll use whatever's available on the website. We have, for instance, the tax rolls that are for the county of Rensselaer are all online. We're going to be using those to distribute. So some of the information about who owned the property is going to be available publicly that way too. So again, we're going to ask people to provide what they have, but if they don't have it, we're going to use public information to supplement that to make sure that everybody's eligible is confirmed.
Okay. Now, stepping back a little bit, discussing both the property damage class 1 for the municipal water owners and then also for class 2, the private well owners. How much money was set aside for this group?
I should have that off the top of my head, but I believe it's $22 million and some change.
Okay.
I think it's 22.7, I believe.
Okay.
But I get you the exact number. I apologize.
No, that's okay. I was thinking it was 22 point something and I couldn't remember the something. That's fine. So you're not handling these 2 classes separately, assuming that all of these people who are involved opt into this, then is it my understanding that that whole group is put together and that's the distribution comes out of that? It's not separate for the one class and a separate pot for the other class. Can you talk a little bit about that?
Right. And the actual number is 20,700,000. So I apologize. I should have had that handy. But yes, the analysis that our expert did compared the properties in the town of Hoosick, including in the village of Hoosick Falls, to the other towns. So the data that we're using to prove the loss of value applied equally to the private well contaminated owners as well as the public water that had a contaminated source. So we're going to treat both groups really as the same once we get through the eligibility status. Once they're eligible for the classes, then the computation of how much they'll receive is going to be the same. And that's going to be done, again, using those publicly available tax rolls for the year 2015. We picked 2015, obviously, because that was the determination of full market value by the assessor was done before the contamination was discovered. So everybody's property was valued using the same methodology in 2015 without the contamination. And that's going to be the starting point. So everyone that's eligible, they'll have a fraction that is used to computate what their amount will be. And the fraction will have a numerator. The top number in the fraction will be the fair market value of their property in 2015, according to the tax assessment rolls for the town of Hoosick. The denominator of that fraction will be everybody's, including theirs, but everybody else's and theirs, total fair market value of all the eligible properties. And that fraction then will be multiplied by $20,700,000 to compute the individual property owner's share of the settlement for the property damage. And obviously, if a more valuable property will get a higher recovery than a lower value property, because what our expert determined was there was a percent effect on the market, and that percent is going to obviously be a bigger number if the value of the property was higher, and a smaller number if the value of the property was lower.
Okay, so it's proportional. So if I owned a $100,000 property and the percentage ends up being a 10%, that would be a $10,000 award, where if I owned a $200,000 property, it'd be a $20,000 award, correct?
Exactly.
Now,
exactly.
What determines the percentage of the property value? And again, you said fair market value. This is not like separate assessments or appraisals or anything like that. It's just fair market value on the town of Hoosick 2015 tax roll, correct?
Yeah, I think I misspoke. The term that they use in the tax roll is full market value. I said fair market value, but that's if you look up the Rensselaer County tax rolls, and they have, the first one that comes up will be the current one, but they have old ones too. And if you go just scroll down, you'll find it. If you hit 2015 and you look up your property, you'll find out what the full market value is listed there, and that would be your number.
Okay. And right now, you can't determine the exact percentage because you don't know how many people are going to be a part of this. But right now, it seems to be, it could be somewhere between 9 and 10% of property value. Is that correct?
That's our best estimate, yes.
And if less people participate, that percentage could go up because it's the same pot
Exactly.
with fewer people.
Exactly.
Okay. Is there anything else you want to say about those two classes before we move on to the nuisance settlement class?
I think we've covered the information on that. Again, some people may think that if they got an appraisal, they would do better or worse. But again, that would defeat the concept of the class action. We needed a mechanism that would be applicable across the board, that wouldn't be an individualized approach. Because if you propose an individualized approach, then you defeat the concept of a class action. Okay. And if people were to try to do that and opt out of the settlement and get their own appraisal, and even if they were to find that their appraiser was saying that their property was diminished by 50%, it's not, it's just impossible for them to prove all that in court without spending, probably 2 orders of magnitude above the difference of what they could get. So we had to come up with a uniform system to meet the class action requirements and to allow these expenses that were enormous to get us to this point to be spread across the entire group so that everybody actually benefited from it. And
Okay.
the numbers that we're talking about here, and we didn't mention this, but I should, the numbers that we're talking about what's going into this class, those are after the attorney's fees are taken out. So there's not going to be any further reduction for attorney's fees or costs. Those are separate amounts that are going to be proposed to the court above the numbers that we're talking about.
Okay. And just as a fluky, I was thinking through scenarios, the village water owners, that makes sense. And the 2015 tax roll makes sense because that's the same date and that's that we chose. But for town residents, they may have discovered it, their PFOA in 2016 or in 2017, but it's still specific to the 2015 tax roll, right?
Yes.
Okay.
But what we couldn't determine for sure is and again, 2016 probably would have been safe too, in that the effect of the contamination probably wouldn't have affected property values in 2016 either, as far as the assessor was concerned. But we used 2015 just so it was clean, so that there was no debate that those full market values had no, were not affected in any way by the contamination.
Okay. And one other thing I wanted to ask about that, specifically the class for private well owners. If there was 0 PFOA detected in their water, they wouldn't qualify for this class, even if they had the POET installed as a precaution, correct?
If there's not any, I don't believe that they did install any POETs for people that had 0 non-detects, but if the law in New York is very restrictive, we have to prove contamination. So even if somebody was to install a filtration system just to be safe. But one thing that I can throw out again is that if for some reason you have no PFOA that's been detected to date, but 5 years from now you do get PFOA detected in your well and you didn't take part in the settlement, you would not be precluded from doing something then, because that would be a new case basically based upon a discovery that happened after the settlement and after the court approved it. So, if you were excluded from this because you had nothing found in your property, doesn't mean if it's found at some later time that you can't take action. With the same caveat that it's hard to do that because of the tremendous expense of proving these cases, but the settlement wouldn't preclude you from trying.
Okay. All right. So let's move on to the third class, which is the nuisance settlement class. Now, I know this is a more specific class, so I'm not going to ask questions. I don't fully understand who's involved. Can you explain who isn't involved in this class?
And let me just explain that a nuisance claim really originated, like a lot of our common law claims, from England. And the concept of nuisance is what we call common law. Common law is court decision made law as opposed to statutory law that the legislature passes. So this is something that we inherited from our English ancestors in the law, and it allows a property owner to sue for a nuisance being created that affects the enjoyment, and the peaceful enjoyment is the word that they use, of your property. So there's 2 kinds of nuisances. There's a private nuisance where people can sue individually, and then there's a public nuisance that is considered common to a big group of people, and you can't sue for individually. It has to be sued for by the state or some other public entity. So what happened was we tried to bring a private nuisance claim on behalf of the people that had private wells, but also on behalf of the people that lived in the village that were on the public water system. And the one claim that the defendants were successful in getting dismissed based upon a legal decision that was made by the court was that the people on public water didn't have a private nuisance claim that they could bring on their own. And so that claim was dismissed. So the only nuisance claims that survived that motion practiced by the court and the decision by the court was the people who had private contaminated wells and the nuisance class is limited to only those private contaminated wells. And the concept of nuisance is that you're entitled to recover for your annoyance and inconvenience caused by the nuisance. And in this case, the annoyance and inconvenience is both being deprived of the use of your water for the period of time they were deprived of that, and also having the POET system installed. So you asked originally whether the property damage people needed a POET system. They didn't, but the private nuisance people did need a POET system installed to be eligible. And so you need to have PFOA and a POET system to be eligible for the nuisance class. And you have to have a private well only. The public water people were dismissed. That claim was dismissed, so they can't participate in that class. Mute again.
I did it again. So
That's okay.
Village residents and those few residents who are in the town but on the village municipal water supply, they cannot be a part of this class.
Correct.
Now, if does this, so let's focus on the properties within the town that can be. Is this for owners and renters, or just the owners?
So the claim for nuisance is based on having an ownership interest in the property, or I'm sorry, having a legal interest in the property, which can be either an ownership interest or a leasehold interest. So the important part of the nuisance cause of action and the damages here to be recovered is that you had to live in the property at the time the contamination was discovered and that the POET system was put in. And if you live there and you either own the property or lease the property, then you would have a nuisance claim. If you owned the property but you didn't live there, you would not have a nuisance claim. Whoever lived there would have a nuisance claim. So renters have a nuisance claim if they were the ones that lived in the property during the period of time that they had their lease and the contamination was discovered and they were told not to drink the water and they had to drink bottled water, and then they had to live with the POET system. Those renters would be eligible for the nuisance class, but owners that owned that property would be able to get the property damage claim, but they would not if they didn't live there and experience the nuisance. In other words, if they didn't have the annoyance and inconvenience of the POET system and the not being able to drink the water, they would not be able to.
Okay.
So
I'm sorry, is there any difference for if it's an agricultural property versus just a normal residential property or a combined use?
Yeah, these are the nuisance is going to be limited again, just like the property damage, to residential properties, but there can be properties that are mixed in both scenarios. So for instance, if you have agricultural property but you have a house on that property that you live in, then the portion of and typically on the tax rolls, that's divided between the zoning for agricultural, which has a different tax rate. It's the homestead part that would be qualifying for that. And if you had a contaminated well, and that's the same for the property damage, it has to be residential. If you have a property that is part residential, that would also qualify. So you could have a business in the downstairs, but apartments upstairs. And in that situation, it would be both. And you had a POET system, you'd get in a nuisance claim. But if you resided there again, or if somebody leases it, they would be entitled to the nuisance claim in that situation.
And
so
in that example, I'm sorry,
partial residential.
Okay, and in that example where you are working out of the property and also living, or maybe you're leasing it, the person working wouldn't qualify. They would have to be the one living there, or would they both qualify?
They'd have to have a legal interest in the property. So just working there would not be enough. You'd have to have a legal interest. And for the same reason, in other words, you could have a family of 10 people. The mother and father own the property and there's 8 kids. Under the law, and not that I agree with this, but this is what the law that we inherited from England, it's only the people with the interest in the property that can recover. So the family of 10 would only have 2 of the 10 that would qualify for the nuisance class because of that requirement. And if it was a family of 10 that leased, it would be the 2 parents that were on the lease. If both parents were on the lease, that would be entitled to the nuisance class. If only one parent was on the lease, then only one of the 10 people would qualify for the nuisance class, because under the law, it requires that you have a legal interest, and a legal interest is determined to be either a legal lease interest or an ownership interest.
Okay, and we talked in the previous classes about the timing of when you would have had to have been owning the property or when you would have had to have the property tested. What's the timing again on this one?
It's the same as the property damage. It has to be at the time the contamination was discovered.
Okay. Now, if you participate in this nuisance claim or subsequently in the previous property damage classes, that means you could not take it on your own to sue specifically for nuisance or property damage. Or if you were in the process of suing for those separately from this, would that take you out of the ability to pursue that? How does that work?
So by definition, people that have filed their own lawsuits are excluded from the class. They can be re-included in the class if they decide to dismiss those lawsuits voluntarily. That's an option. And if they do that, they would be dismissing it against DuPont as well. But they can get out of it if they out of the private suit, but you can't recover twice. So either you're going to go in the class and dismiss your private lawsuit, or you're going to continue with your private lawsuit. Some people that have been injured already, that have illnesses, may have included in their suit for those damages for the illness, property damage, and some of the other damages. And those people would be excluded unless they choose to dismiss those specific claims and join the settlement. So that will be an option. That's going to be a limited group of people, because there's only, I think, about 40 individual lawsuits that have been filed, and not all of them are entirely from the class area. But it's not going to be a large segment of the population that's going to be in that boat, and their individual attorneys will be the ones that they should talk to about what the best option is for them.
Okay. All right. That's great. That's very helpful. Now, can we talk about the medical monitoring settlement class?
Sure. I think the one thing that we should tie up though, Rob, is what's the amount that people are going to get?
Oh, geez, I totally forgot that.
Class.
Yes.
That's okay. So the nuisance class number is $7,761,683. That's the pot of money, and that will be divided equally with everybody that qualifies in the nuisance class. So it's going to be pro rata. The number of people that qualify, we tried to estimate that. We believe there are approximately 500 homes that would be eligible, and we estimated that there'd be approximately 1.5 eligible people per home. That is an estimate. It's not something that we had enough information to be more specific than that. But if that's the case, then everyone should receive somewhere in the neighborhood of $10,000 if everybody participated. If there are more than 1.5 eligible people per eligible home and everybody participates, then it'll be a little less than that. If not everybody participates, it'll be a little bit more than that. So somewhere in the vicinity of $10,000 per eligible person, but that isn't an exact number. It's going to have to wait until we see the claim forms to give a more precise number, but it will be somewhere in that vicinity. And just as another caveat, we talked about opting out. If there's the way the settlement is worded and the requirements, if a property is owned by two people and one of them decides to opt out, the other one is automatically opted out. There's not a choice of splitting the baby there. The way the settlement is and the agreement was reached, if somebody opts out, and that brings your other co-owner, whether they want to or not, is automatically opted out.
Okay. All right. So now the fourth class is the medical monitoring class. Now this was a pretty big deal, because I don't think there have been historically a lot of class settlements like this that have included a medical monitoring. Of course, this, and I'm assuming you're going to talk about this, ties a lot into the C8 science panel and what came out of that settlement. But can you talk first off about who exactly specifically would fall under this class? Residents, owners, village, town, all of that.
So the medical monitoring class is the broadest of all the classes, and it is defined as anyone who is tested and has greater than 1.86 parts per billion in their blood on any blood test that they've gotten, regardless of when it was, whether it was 2016, 2018, or even at present. Anything above 1.86. 1.86 was chosen by the medical experts, and it's more of a demarcation of what is highly likely to have been from contaminated groundwater versus background, where you might have gotten it from some consumer product or something else. So it has to be above 1.86 is the first criteria. The second criteria is that you can establish that you spent at least 6 months residing at a home that had contaminated water between 1996 and 2016. And that's going to be something that has to be done by a sworn declaration from the person as to the address they lived in, and that they lived there for more than 6 months. And that's going to be sufficient proof that they did. But they have to designate a residence that was either on public water during that time period, or one that was found to have a contaminated well after that. And so those are the two basic criteria, that, residents at a contaminated home for 6 months during that 20-year period, and also having a PFOA blood test that shows PFOA levels in your blood above 1.86 parts per billion.
All right, a bunch of follow-up questions on that. First off, if they weren't tested in those 2 rounds of blood testing, could they be tested now, find that they have the higher than the 1.86 threshold?
Yes,
and be part
yes,
of
they
this?
can. And we will be sending out information and providing people with information of how to do that if they haven't been tested and they want to be part of that program.
Okay, that's great. Second one, nursing mothers, there's documentation that this stuff is passed on through nursing mother's milk into the child. Is there a caveat for anyone who fits within the 6 months within the time frame, but was nursing and may have had a lower number?
That's a great question, and actually that's yes, and that was specifically included. And it's not only nursing mothers, Rob, but it's also passes to the baby through the placenta. So children that to babies that are born to mothers with high PFOA levels are born with high PFOA levels. So the criteria includes babies that were born to mothers that fit the criteria. So if the mother had above 1.86 and then the baby is tested and has above 1.86, even though the baby never drank contaminated water, if the baby was born after the contamination was discovered, but the contamination flowed from the mother being exposed back in that 1996 to 2016 area, then the child is eligible for medical monitoring, and that's part of the settlement.
So in a sense, and correct me if I'm wrong, if there was a mother who was in the area between 1996 and 2016, and they can clearly prove that they were either had through the village water supply or through a private well, had PFOA in there, then any child born within that range could be part of this class. Is that correct?
Any child born to that mother who qualifies, and the child has to be tested as well. So the child has to have their blood test, and their blood test has to be above 1.86. Then they would qualify for the medical monitoring settlement.
Okay. What about renters? If someone rented during this time frame, they would still count, correct?
And this would include, the people on the lease and every child of the family, whether they're owners or on the lease. If they resided at a home that had contaminated water and they have above 1.86, they qualify. So there's no property ownership requirement for this one, or property, leasehold interest. It's just a matter of people that resided and drank contaminated water and have that 1.86, and it's within that 20-year period and a 6-month period.
Okay, what about people who worked in a business? I know it's a business, so I think I know what the answer is, that was on, say, the village water supply that would have had contaminated water between that period.
So again, for the same, even though it seems like those people should be included for the same reasons I said that we could not do a class action if there's too much variety.
Okay.
We had to keep it simple, and it had to be people that resided. So those people that were passing through town or might have worked for a period of time in the village, if they didn't reside at a place where they had contaminated water, then they will not be part of this settlement. They also would not lose their rights. I mean, they would still have independent rights. Again, it's a sort of two sides of the same coin. If you qualify, you're going to be bound by the settlement. If you don't qualify, then you still have whatever rights you had before.
Okay, that was kind of what I expected, but I just wanted to kind of cover all of the bases. Now, first off, how much money has been set aside to do this program? And then secondly, what does the program entail for people who participate? What are the sort of preventative things that they're going to be looking for?
So the amount of money that's been set aside for this is $22,800,000. And this would be a program that we will have a general administrator that is going to deal with all of the claim forms and parse through and determine eligibility and then divide the other class monies. But once the number of people that are eligible for medical monitoring is determined, then that money is going to be turned over to a different administrator who is going to be responsible for administering the program for the length of the program. The length of the program is going to be 10 years, or if the money runs out before that, then it would end before 10 years. But we estimate for 2,000 people, which is the number that we've been using based upon what we've learned from the Department of Health as to the people that have been tested thus far that would meet the criteria, we believe would meet or possibly meet the criteria. We believe there's enough money to last for 10 years, and that's based upon a very robust economic assessment of what the test will cost and factoring in inflation and all those sorts of things. So the diseases that are part of this, in order to get to this point, we were obviously required to prove to the court that PFOA was capable of causing, or more likely than not, causing certain illnesses. And one of the experts that we retained in this case was one of the C8 panel experts, Dr. Savitz, David Savitz from Brown University. And it was his opinions that we utilized based upon the epidemiological literature of which of the diseases that have been established to more likely than not be caused by PFOA exposure. And those include two forms of cancer, testicular cancer and kidney cancer. They also include ulcerative colitis and thyroid disease, hyperlipidemia, which is basically high cholesterol, and elevated levels of liver enzymes as well as uric acid are among, and also preeclampsia or pregnancy-related hypertension. So these are all conditions that would be included. Once you determine that there are certain conditions that can be caused by PFOA, then the next determination is, are there tests that can be administered that would provide for early diagnosis and then the opportunity for early treatment? So, for instance, there are some diseases that there are no tests for, and there are some diseases that even if you get them early, you don't change the outcome. So we had to then hire another expert who did that analysis. His name was Dr. Alan Ducketman. He was also involved in the C8 project. And he proposed a medical monitoring plan that would provide the types of tests that would be helpful to people who come down with these diseases so that they would be diagnosed early. And so that combination of things is what we needed to do. And under the plan, then, what will happen is that Dr. Ducketman and the medical monitoring administrator will then select a number of physicians in the area that will be trained to administer these tests at no cost to anyone, to any of the participants, and they will be administered or available to be administered on a yearly basis. So people will go to one of these physicians, they will fill out a survey form to provide the physician with information about their background to help them make determination of what would be best for them. They'll be given this battery of tests. None of them will be, there'll be some blood tests, some urine tests, and some other physical evaluations. There won't be anything invasive. And then they will get the results of their tests back, but all of that will be paid for by the program. And that will be repeated every year for the 10 years as long as the money holds out. There's also going to be availability for people that qualify for the program but that don't live in the area, that can travel easily to one of the area physicians that's going to be established. And we intend to have not only physicians in Bennington and the physicians in Hoosick Falls participate, but also physicians in Troy and Albany to cover more of the Capital District area. But then if there's somebody that's moved to Georgia, for instance, but qualifies for the program, they're going to be eligible as well, and will adapt that their local physician can then bill for those same tests through the medical monitoring program, and they won't have to pay either. So this is one that is going to be more far-reaching. In other words, there are going to be people that live for 6 months at a contaminated property that are no longer in the area, and they're going to be harder to reach. And we want to encourage people, if you know people that fit that description, to reach out to them and tell them to get to the website and see if they qualify, if they want to participate. The other wrinkle to this is that in the settlement, historically, there haven't been that many medical monitoring programs that have been approved, and the C8 project was a little bit different in how it was administered, and it hasn't been as ongoing as this one will be. But it's historically, the participation rates have not been 100%. In other words, everybody that is eligible doesn't participate for whatever reason, probably similar to why everybody that's eligible for vaccines don't get vaccines, right? It's just not everybody chooses to do that. So we anticipate that that there's going to be a high percentage of people that participate in Hoosick Falls based upon the level of interest and the level of concern, and also the level of PFOA in people's blood that has been alarming to a number of people. And so we expect the participation to be high. But if it's not as high as we anticipate it to be, and there's money left over, then what we have in the plan is that everyone who participated in the plan will then get a payment at the end of the process, if there's money left over, that they can use to continue funding their testing if they want to, or to use for some other purpose. And that will be distributed pro rata based upon participation. So if someone participated all 10 years of the program, if it lasts the 10 years, they would be entitled to one share of pro rata. If somebody participated in 50% of the testing that was available to them, they would get half a share. And we think this is a good system, not only because it makes sure that everybody gets a benefit from this, but it also encourages people to participate, because they may actually get an additional cash incentive at the end of the program if they participate for the full length of it, or at least in part of it. The other part of the program is that they will actually get an incentive payment at the outset too. They'll get a $100 payment for beginning participation for filling out the first survey. But then the only other cash payment they will get is if there's money left over, and it's divided at the end.
Okay, that's very helpful. Now, we talked earlier about
I think I just want to add one more thing,
sure,
to make it clear. This is a screening program. It's not a treatment program. So if somebody goes through the screening and they're found to have signs and symptoms of one of these illnesses, the program will not treat them. They will be sent to either their treating physician or some other physician that will help them with whatever that suspected condition is, and will provide that treatment, and that will not be paid for by the program. But if somebody does develop a PFOA related disease, that would trigger a different claim, legal claim, that is not being given up, and they could bring a lawsuit that would include their medical expenses that were incurred as a result of that illness, as well as their pain and suffering for that illness. So the program, just to be clear, is not a treatment program. It's a screening and diagnosis program that will help detect these illnesses early. But once they're detected, or there's a suspicion that they're present, then it'll be up to another physician to actually provide the treatment. Just wanted to make that clear.
Okay. Okay. Now, we had talked earlier about a threshold of involvement for the various classes, and I think legally you guys aren't allowed to divulge what that threshold is, but is there a threshold here where if you don't hit a certain threshold, this doesn't happen?
The threshold issue is only as it applies to the people that opt out. So it doesn't, we don't have to in advance predict how many people that are eligible that haven't opted out are actually going to participate. What we call the escape clause for the defendants is if, for instance, if 50% of the eligible people decide they don't want to participate in the settlement, then the defendants have the right to either renegotiate the settlement or to completely scrap it. But again, because of the financial, the economic issues involved in bringing your own lawsuit to try to recover these damages and the tremendous expense involved in that, it's just not really practical for anybody to do that. And so it's not going to be surprising if a small number of people opt out, just because there's always a small number of people that will do anything to be contrarian, I guess. But it would be against their own interest to do it. But we don't anticipate anywhere near the percentage that would be needed to put an end to the lawsuit. And even if that was exceeded, it's highly more likely that the defendants would simply want to reduce the amount of money that they pay into the settlement as opposed to scrap the whole thing. So I don't think I think it's highly unlikely that there's going to be anywhere near the number of opt-outs that would even give them that right. But if that did happen, I think that they would just renegotiate the numbers to some extent and allow the settlement for the people that wanted to participate. And I think that there's very, very, you never say never, but I just can't imagine a scenario that enough people would opt out that this would put an end to this settlement.
Okay, so I've hit pretty much, I think, everything that I thought I would have questions about or people have asked me about. If people have more questions about specific scenarios or their specific situation, how do they go about answering those?
So
Answers for those?
When the website comes up, there's going to be a complete frequently asked questions section that's going to have a lot of information on them. And that there's also going to be an opportunity for people to ask specific questions. And we are going to have the public meetings that will permit people to ask questions in public. And there will be other mechanisms on the website for them to ask specific questions that we'll do our best to try to answer. The notice form also is going to be very inclusive with regard to the information that's in it. So we would highly recommend that you read everything that you're provided with, both on the website, but also in your mailing. And it should be fairly self-explanatory. There are going to be sort of a few unique situations that may require more analysis by us to make a determination and by the general administrator. And, those will be dealt with in as expeditious a manner as we possibly can.
Okay. And will the mailing that goes out be also on the website in case people didn't get the mailing for whatever reason?
Yeah, all of the forms, the notice form, the claim forms, all of the associated things that they have to fill out and sign will all be available in PDF format that can be downloaded from the website. So if you didn't get a mailing, you can go to the website. If you did get a mailing and you lose it, you can go to the website. There'll be multiple opportunities to get the forms. Again, you have until January 23rd to complete the forms, and there's going to be multiple opportunities to get those forms that you'll need and to get all the information that you need to determine whether you're eligible. And if you have any doubt whether you're eligible, submit a claim form and let the administrator determine whether you're eligible. Don't rule it out. If you think there's a chance, complete the form and give it a shot, because it's again, it can be rather technical and there are some technical restrictions. One of them is the blood testing, and that's also going to be available. If you haven't been tested, we'll provide information on how to do that on the website, so you can contact the Department of Health and get tested.
Okay. Do you have a website name yet or website address yet?
Yes. and that will be publicized, but let me look that up again because I don't have it memorized. It's going to be www.hoosickfallspfoasettlement.com.
Oh, that's easy.
So hoosickfallspfoasettlement.com, and probably if you Google Hoosick Falls PFOA settlement, that'll be the first thing that comes up anyway.
Okay.
If you forget the exact wording, I think Google will probably take care of that for you.
All right. Is there anything else you wanted to talk about?
I do want to mention that the settlement is a substantial settlement, but we don't think it's the end of the case. As I mentioned earlier, we have 3 of the 4 defendants, Honeywell, which is the company that took over Allied Signal, which was the company that bought other companies that ran the plant since the 60s up through 1996. We have settled with Saint-Gobain, which purchased Furon in 1999, and Furon purchased the McCaffrey Street plant in 1996. And Saint-Gobain is the legal entity that's responsible for the Furon years, as well as the years from 1999 through 2003, when the plant was, when the fabric coating portion of the McCaffrey facility was moved to New Hampshire. So, and we've also settled with 3M company. 3M was the company that invented APFO, which is the precursor chemical to PFOA, and made it. And that was then sold to the companies that made the dispersion products that were used at McCaffrey Street. So those 3 defendants are the ones that we're settling with, but the 4th defendant is DuPont. And of course, DuPont is the company that was the leader in Teflon technology and sold a substantial percentage of the products that were used for fabric coating at McCaffrey Street in Hoosick Falls. Came from DuPont. DuPont also, of course, is the company that had the most knowledge of PFOA hazards as early as with 3M, but even more so with regard to the potential for environmental contamination and water contamination. And that if anybody that's seen the movie Dark Waters and knows the story of West Virginia and their Washington Works plant in West Virginia and the towns that were in Ohio and West Virginia along either side of the Ohio River. So we believe we have a very strong case that DuPont knew or should have known of the potential hazards of their products and didn't warn the processors like Allied Signal and Furon and Saint-Gobain of all the information that it had. So that's the basis of our claim against DuPont. And DuPont has chosen not to join the settlement. So the case is going to proceed against DuPont, and our hope is and our belief is that we are going to win that case against DuPont. And when we do, then the amounts that people receive will be enhanced by whatever that amount is that we can get from DuPont. And we believe that we would distribute that money identically to the way the settlement's set up. In other words, that would that what people are getting now is in a sense a substantial payment, but we don't believe it's going to be their final payment. And right now, legally, where we are is the court has to decide whether to certify a litigation class to go to trial against DuPont, and we expect that decision to be coming down anytime now.
Okay. Anything else?
I think that covers it. Again, I think that we are very pleased with this settlement. We think it's a really good settlement for the people of Hoosick Falls and the town of Hoosick. And we encourage everybody to study their notice documents and to make sure that they understand it. But for the reasons I've already articulated, the alternatives are not good for people. It's not going to be profitable for them to opt out and to try to find lawyers who are going to be willing to spend the amount that we've had to spend to get to this point. As I said, we spent over $1 million for various litigation costs, including experts, including the millions of documents that we had to review and put onto a platform that we could do that. and especially with all of the depositions that we had of taking testimony with witnesses, taking testimony of experts. It's a very expensive process. And again, the ability to actually come out ahead by opting out is going to be zero. So and especially again, in light of the fact that we do expect further compensation to come along if we are successful against DuPont, we think that this is a settlement that people can't refuse if they're being rational and they study it. So we invite their questions. We're happy to try to answer them, but I think in the long run, this is the best deal that we could get, and it's a very good deal. And I think people should be, happy. And the other thing too to understand is that the case against DuPont may go on for another couple of years before we can get to trial. And the settlement provides, for compensation to occur and to medical monitoring to start by, early next year to mid next year. And that's going to be a very beneficial thing, both to get people to get their money sooner, to compensate for their property devaluation and their nuisance, but also to get the screening program started so that we get that going as soon as we possibly can to try to save lives and to have better outcomes for anybody that's unfortunate enough to get sick. And if we didn't settle, then we wouldn't expect that to happen probably for another 2 or 3 years, which again would make us now 7 or 8 years after the contamination was discovered. And that's just not, that's just not something that would be beneficial to anyone.
Okay. Well, Steve Schwarz, thank you very much for taking this time to answer some questions and start the process of getting information out to people and your work on this. Appreciate it very much.
Thanks for the opportunity. And again, we look forward to having more questions and giving more information as the weeks go on. And again, once the notice begins, I think people will get all of the information that we've talked about and more.
All right. Thank you.
Thank you.